40 years on this bench, I have seen things in this room that would keep most people awake at night. I have watched defendants collapse into tears the moment they realized the evidence was not going their way. I have watched witnesses crack under a single question they did not see coming. I have watched attorneys, expensive ones, confident ones, the kind who walk in like they already know how the morning ends, go completely pale when the facts turned against them. I have been cursed at. I have had people storm out. I have had a man throw a folder of documents at the bench and tell me I had no idea what I was doing. I have seen people cry, beg, threaten, bargain, and perform every version of desperation and arrogance that a human being is capable of producing under pressure. But I have never, not once in 40 years, been left speechless. Until March 6th. That morning, a man worth more money than most people will see across several lifetimes looked me directly in the eye in my own courtroom with a room full of people watching and said 4 words that stopped me completely cold. He said, "I own you, Judge." And for 3 full seconds, I had nothing. No response, no gavel, no words at all. Just the sound of the clock on the wall ticking and a silence so complete I could hear the person in the 3rd row shift in their seat. And the feeling, slow, clarifying, absolute, that something had just changed in that room in a way that could not be taken back. What happened in the minutes and hours that followed is the reason I am telling you this story, because this is not really about Preston Whitmore IV and his $2 billion. That part is almost beside the point. This is about a 68-year-old woman named Dorothy Ellis who drove herself to a courthouse alone in a blue wool coat and a pair of white gloves, carrying 11 months of careful, patient work in a plain manila folder. A woman who refused, quietly, stubbornly, completely, to let money be the thing that decided what was fair. The case came to me as a civil dispute. On paper, it looked simple enough. Dorothy Ellis, age 68, retired, was challenging an eviction notice. The defendant was Preston Whitmore IV, 44 years old, 4th-generation wealth, real estate portfolio spanning 5 states. His grandfather had started the company. His father had expanded it. Preston had inherited it at 30 and spent the following 14 years multiplying it. He had been profiled in business magazines. He sat on the boards of 2 hospitals and a university. His family name was on a building at a law school in Connecticut. He had arrived that morning in a black SUV with a driver and a legal team that billed by the 6-minute increment. His lead attorney, Clifford Barnes, had a reputation that preceded him in courtrooms considerably more elevated than mine. Barnes had a way of filling a room, the kind of practiced, expensive confidence that communicates before a single word is spoken, that his client expects to win and has the resources to ensure it. Dorothy had arrived alone. She had lived in the same apartment for 22 years. 22 years in the same building, the same neighborhood, the same 3 rooms where she had built a life from almost nothing. She grew up in Birmingham, Alabama, the daughter of a steel worker and a woman who took in other people's laundry to help make ends meet. She was the first person in her family to finish high school, the first to go to college, which she did on scholarships and a night shift at a diner. She moved to New York in 1982 with $300 and a suitcase that was held together with a belt. She got a job with the Postal Service, and she kept it for 31 years, walking the same route through rain and snow and New York summer heat that bends the air above the pavement, and she was never late, never careless, never the kind of employee you had to follow up with twice. She raised 2 children in that apartment, largely on her own. Her son was now teaching school in the Bronx. Her daughter was a nurse in Philadelphia. Dorothy had been planning to spend her retirement there in those 3 rooms, in the neighborhood where she knew every shopkeeper and every neighbor and every crack in the sidewalk. She had earned that. She had paid for it month by month for 22 years, never once late. Preston Whitmore IV had purchased the building 14 months earlier. Within 60 days, every long-term tenant had received an eviction notice. No violations, no complaints, no cause of any kind. He wanted to gut the building completely, strip it to its bones, renovate it from the ground up, and reopen it at rents that people like Dorothy, people who had lived there for decades, people who had built their lives in those apartments, could not come close to affording. There was already a sign in the lobby, a glossy rendering showing what the building would become: exposed brick, a rooftop terrace with string lights and lounge furniture, a fitness center, a concierge, starting at $6,000 a month. The sign had gone up while tenants were still living there, while Dorothy was still sleeping in the same bedroom she had slept in for 22 years. She told me later that she walked past it every morning on her way out and every evening on her way back in, and that it took her about a week to understand fully what it meant, that she was not a tenant to be accommodated. She was an obstacle to be cleared. Dorothy had decided to fight it on her own without a lawyer, armed with nothing but time and stubbornness, and the belief, fragile some days, she would tell me later, but never entirely extinguished, that somewhere in this system, a person who had done everything right should still be able to keep her home. That manila folder contained 11 months of work. Every email she had sent to the property management company after receiving the eviction notice, printed, dated, organized. Every phone call she had made, logged with the time and the name of whoever had answered, or more often, had not. Every certified letter sent and tracked and never responded to. She had printed the relevant sections of the city's tenant protection statutes and written her own notes in the margins in neat, deliberate handwriting. She had collected signed statements from 11 of her neighbors, every one of them with a similar history in that building, most of them already gone. She had pulled the building's full permit history from the city's public records database. She had figured out how to use that database herself, sitting at her kitchen table with her reading glasses on, because no one had offered to help her. She had found the timeline: acquisition in October, eviction notices in December, the first renovation permit filed in February, the lobby sign in March advertising the building's new identity to anyone who walked through the door. It was, in short, exactly what it was: an acquisition designed not to improve a building, but to replace the people in it with people who could pay more. Documented, time-stamped, undeniable. When she laid the last page on the table and looked up, the courtroom was very quiet. Preston Whitmore IV at the defendant's table looked at his phone. I called the case. His lead attorney, a polished man named Clifford Barnes, whose reputation preceded him in courtrooms considerably more elevated than mine, immediately moved to dismiss on procedural grounds. It was a sharp motion, technically competent, and entirely designed to end the case before Dorothy had a chance to speak. I denied it. Barnes blinked. He was not accustomed to that word arriving so quickly. I turned to Dorothy. Mrs. Ellis, you are representing yourself today. This court will give you every opportunity to present your case fully. There is no rush. Take all the time you need. She looked at me the way people look at you when they have been told for 11 months that the system was not built for them, and they are not entirely sure they believe you yet. Then she nodded and opened her folder. What happened over the next 40 minutes was one of the quietest, most methodical, most devastating presentations I have witnessed in this courtroom. Dorothy Ellis did not perform. She did not plead. She did not ask for sympathy or lean on her age or her years of service or anything else that might have softened the room. She simply laid out the facts, one by one, in the order she had organized them, and let them speak for themselves. Her voice was steady throughout. Her hands did not shake. She had organized 11 months of documentation into a sequence so clear that even a person with no legal training could follow exactly what had happened and exactly why it was wrong. She showed the court the timeline of the acquisition, the eviction notices that went out 60 days later, before a single renovation permit had even been filed, the sign that appeared in the lobby 2 weeks after that, the rendering of the rooftop terrace, the exposed brick, the amenity list, the starting price of $6,000 a month. She showed the court her own payment history, 22 years of receipts she had kept in a shoebox and pulled out one by one when this started. She showed the statements from 11 neighbors, all of them with similar histories, all of them gone now or in the process of leaving. She showed the unanswered emails, the logged phone calls, the letters sent certified mail that were never responded to. When she placed the last document on the table and looked up, The room was very quiet. I watched Preston Whitmore IV during this. He glanced at his phone twice. He leaned toward Barnes once and said something I could not hear. He did not look at Dorothy. Not once during those 40 minutes did he look at her. When she finished, I turned to the defense. Barnes rose and began presenting the procedural argument again, this time more expansively, with citations and case references and the kind of layered legal framework that is designed to make a straightforward situation seem too complicated for a simple resolution. I let him finish. It took 11 minutes. When he was done, I thanked him and asked to hear directly from his client. Preston Whitmore IV stood. He had the bearing of a man who had been standing in rooms full of people he considered his inferiors his entire life and had genuinely, long ago, stopped noticing. He was not rude exactly. He was something more difficult than rude. He was entirely indifferent. He spoke about property rights. He spoke about the legal framework governing no-fault evictions in this state. He spoke about market conditions and renovation timelines and the responsibilities of ownership. He was accurate. He was fluent. He spoke like a man who had explained this particular position many times before and had never once been seriously challenged on it, because he never had been. I asked him if he was aware of Dorothy Ellis's payment history in the building. He said he did not personally manage individual tenancies. I asked him if any of the evictions in the building had been triggered by tenant conduct, any complaints, any violations, any cause at all. He said no. I asked him what the projected revenue difference would be between the current rents and the post-renovation rents. He quoted a figure. It was, in practical terms, more money per year than Dorothy Ellis had earned across the entirety of her postal career. I let that sit for a moment. Then I told him that the legal framework he was describing was real, that his procedural standing was legitimate, that the statutes he and Barnes had cited were exactly what they said they were. I told him the court recognized all of that without reservation. And then I told him that recognizing a legal framework and endorsing what that framework is being used to accomplish are two entirely different things, that this court concerns itself with both, that having the right to do something has never, in this courtroom, been the end of the conversation. He looked at me with a particular expression of a man who has never had that distinction drawn for him before. Not confusion exactly, more like the mild surprise of someone who has encountered an unexpected obstacle in a place where he was not used to finding them. His attorney leaned toward him. I could not hear what Barnes said, but I could read the body language clearly enough. Barnes was telling him to stop, to sit down, to let the lawyers handle it from here and stop talking. Preston Whitmore IV looked at his attorney. Then he looked back at me. He straightened his jacket. He set both hands flat on the table in front of him, which I noticed because it was deliberate, almost ceremonial, like a man preparing to say something he had been building toward for a long time. His voice when he spoke was calm, almost pleasant, the tone of a person who is not angry, not defensive, not threatened, the tone of a person who simply wants to clarify how things work. Your Honor, he said, I appreciate the court's time. I genuinely do. But I want to be straightforward with you, because I think we'll all leave here faster if I am. He paused for just a moment. I own over 60 properties in 4 states. I have more legal resources available to me than this court processes in an average calendar year. I have been operating in this space for 2 decades. I know precisely what the law requires of me and precisely what it does not. His eyes met mine and did not move. I own you, Judge. 3 seconds. Just 3 seconds. But I have replayed them more times than I can count since that morning, and they remain the longest 3 seconds I have spent on this bench. I have thought about those 3 seconds many times since that morning. People ask me what I felt in that moment, and I have struggled to describe it accurately. It was not fear. It was not even anger exactly. What I felt was something closer to the particular stillness that settles over a room when something that has been building for a long time finally arrives. He had not invented the belief he was expressing. He had been raised in it, surrounded by it, confirmed in it by every institution and every transaction and every interaction of his adult life. He was not trying to shock me. He was not trying to intimidate me. He genuinely believed it was true. And that, somehow, was the most clarifying thing of all. Barnes had gone the color of old paper. His co-counsel was staring at the table as if he hoped to disappear into it. The court officer by the door had not moved, not even to breathe, it seemed. Dorothy Ellis sat with her hands on her folder, and she did not react at all. I understood, watching her, that she was not surprised. She had known for 11 months exactly what she was dealing with. The only question for her had always been whether this room would be different from every other room she had walked into during those 11 months. Every office where someone had looked at her file and quietly suggested she reconsider. Every phone call where a polished voice had explained gently why her position was unlikely to succeed. She had heard the version of those 4 words many times over. She had never heard them said this plainly. I picked up my gavel. I set it back down. I did not need it. Let the record reflect, I said, that the defendant has stated on record and in open court that he owns this court. I looked at Barnes. The look was enough. I am calling a 20-minute recess. I strongly suggest you use it. Barnes was out of his chair before I finished the sentence. During that recess, I sat in my chambers with the door closed, and I thought about my father. He came to this country with almost nothing and spent his entire working life in construction, laying foundations, framing walls, pouring concrete in winter cold and summer heat, building things that would stand long after he was gone. He earned an honest wage. He never had a driver or a legal team or 60 properties in 4 states. He had a work ethic and a set of values he held onto with the same grip he used on every tool he ever picked up. He used to tell me that men who feel the need to announce what they own are almost always announcing what they are afraid of losing. Real authority, he said, is not declared. It is demonstrated. You earn it quietly, over time, by what you do when no one is watching and when no one is making you do it. The day you have to say it out loud is the day you have already lost it. I sat there and thought about that for the full 20 minutes. I thought about Dorothy Ellis, who would earn 31 years of perfect attendance, who would earn 22 years of on-time payments, who would sat at her kitchen table with her reading glasses on and taught herself to navigate a public records database because no one else was going to do it for her. I thought about what it had cost her to walk into this building today. Not in money, she had none to spare, but in dignity, in nerve, in the simple, exhausting act of believing that her careful, quiet, lifelong effort to do everything right should count for something. I thought about Preston Whitmore IV, who had inherited the foundation and spent his life adding floors to it and calling that construction. When we returned, Barnes requested a settlement conference. The terms were these. All eviction proceedings against long-term tenants were withdrawn. Dorothy Ellis received a 5-year lease renewal at her current rate with a cost of living cap on any future increases. Preston Whitmore IV's company made a contribution, the amount was not small, to a tenant advocacy organization that Dorothy chose herself. He did not look at her when the terms were read into the record. She did not look at him. She did not need to. Before I closed the case, I addressed the courtroom. I said that this court does not belong to anyone with a checkbook or a property portfolio. It belongs to every person who has ever walked through those doors with a legitimate grievance and the courage to bring it here. It was built for Dorothy Ellis. It was built for the 11 other tenants in that building who had done everything right and still woken up one morning to find it was not enough. It exists precisely because power, left entirely to itself, does not self-correct. That is what courts are for. Not to be obstacles to people with resources, but to be a room where resources do not decide the outcome. A room where a woman with a manila folder and 11 months of careful work can stand across from a man with 17 pages of procedural arguments and be heard with equal seriousness. I said that I had been on this bench for 40 years, and I had learned one thing above all others, that the people who announce what they own are almost never talking about property. Preston Whitmore IV left without speaking. Dorothy Ellis put her papers back in her folder one by one in the same careful order she had kept them all along. She smoothed the cover. She stood. She looked at me for a moment with those steady, tired, entirely undaunted eyes. "Thank you, Your Honor," she said. "You did the work," I said. "I just made sure it got heard." She put on her white gloves. She picked up her folder. And she walked out of my courtroom and went home. To her apartment, her 3 rooms, her home of 22 years. I sat at that bench for a long time after the room cleared. The afternoon light came in through the windows at a low angle and fell across the plaintiff's table, across the spot where Dorothy's folder had been, and I just sat there and let the quiet settle. I thought about those 4 words and what they revealed, not about Preston Whitmore IV specifically. I have seen versions of him before, and I will see them again. What struck me was the completeness of the belief, the total, unexamined certainty that money accumulates into a kind of sovereignty, that enough of it eventually places you in a separate category, above the ordinary obligations, beyond the ordinary rules, exempt from the ordinary requirement to justify yourself to anyone. He was not performing arrogance. He was not posturing for the room. He genuinely believed what he said. He had believed it for so long, in so many rooms where no one had ever seriously pushed back, that saying it out loud in a courtroom had not even registered to him as a risk. I thought about Dorothy, who had known that belief was waiting for her when she filed her case, who had understood, probably from the first phone call that went unanswered, exactly what she was up against, and who had responded to it not with anger, not with noise, but with a manila folder, with documentation, with the patient, unglamorous, deeply serious work of building a case 1 page at a time over 11 months at her kitchen table alone. There is a kind of strength in that I find difficult to name properly. It is not dramatic. It does not make for easy headlines. It does not announce itself. It just shows up, prepared, on a Tuesday morning, and does what it came to do. She could have walked away. Most people do, and I do not blame them. The weight of it is real. The resources are genuinely unequal. The system is genuinely imperfect. I am honest enough to say that not every story like this one ends the way Dorothy's did. Sometimes the Prestons of the world do win, and the Dorothys go home to start packing. That is the truth, and I will not pretend otherwise. But on March 6th, in this courtroom, Dorothy Ellis did not walk away, and the reason the system worked on that day, the only reason, is because she refused to let it fail her. She prepared. She showed up. She stood at that table, and she presented 11 months of careful work with a steadiness that I have rarely seen matched by lawyers who have been practicing for 30 years. And when a man with $2 billion looked her in the eye and implied, through 4 words directed at me, that none of it mattered, that money made all of it beside the point, she sat with her hands on her folder and she did not react, because she had always known he believed that. The only question had always been whether this room would be different. It was. My father used to say that the difference between what you own and what you are is the only difference that matters in the end. Preston Whitmore IV owns a great deal, but Dorothy Ellis, with her shoebox of receipts and her handwritten margin notes and her white gloves, she is something that cannot be purchased or inherited or announced. She is what it looks like when a person refuses at every turn to be made smaller than she is. She won. If this story stayed with you, if you believe that showing up still matters, that preparation and patience and quiet persistence can still be enough, share it with someone today. Someone who needs a reminder that the system, imperfect as it is, still has room for people who do the work. Subscribe to this channel because there are more stories like this one, stories from 40 years on this bench that I am not done telling. And leave me a comment. Tell me about someone in your life who showed up when it would have been so much easier to turn around. Tell me their name. People like Dorothy Ellis deserve to be remembered.